Hey, welcome to today's video. Today we're taking a look at the brouhaha surrounding the Fortnite video game. Specifically, do Fortnite dance moves qualify as copyright infringement? So Fortnite is a very popular video game. Just reported earnings of $2.4 billion for the last fiscal year. And when you're an attorney and you represent a client of this sort, you tend to have an idea what's coming next. And those would be lawsuits. I know, cynical. But you do find the more money your client makes, the more righteous people get about some issue. It's welcome to the law. So I am Richard Chapo. I'm an attorney in San Diego, California, and I've been advising online businesses for about the past 20 years. I am not a video game attorney. I don't specialize in this field. I don't even really get involved. But a lot of this bleeds over towards the internet, so it's worth discussing. And of course, a lot of people have questions about this. So my video game bias. Let me qualify this video by saying, 1, I've never played Fortnite. 2, I haven't seen the dance moves in videos or anything of that sort, so I'm not sure what's the contested aspect of it. And 3, I haven't played video games in general in a very long time. The reason being for that, I was dating a lovely young red-headed lady who had a son, and she and her son and I would play video games, and her son used to abuse me. It was just horrible. He would wipe the floor with me. I think I once got stuck on a level of Halo for like 3 days with him mocking me the entire time. And yes, there was therapy involved and mental scarring, and I'm also blaming my weight gain on him too, because hey, why not? So anyways, if I mention something regarding the Fortnite game and how it's played and doesn't make sense, that's why. So it's probably not going to really affect the copyright analysis in this. So the infringement lawsuits, there's actually a number of them. The one that's getting all of the media play, of course, is the Carlton dance from the actor in the Fresh Prince of Bel-Air TV show. However, there's another one filed by 2 Millie for the Millie Rock dance that's also of interest because it involves some additional claims, specifically a trademark claim. And then there are a couple of other lawsuits as well, but they're getting less play. Basically, the same law firm is representing all of these parties. And so, there you go. A lot of the claims are going to be pretty similar. Let's just put it that way. Now, everybody's focused on the infringement aspect of these lawsuits, but really, I think you have to step back and first look at the dances themselves and a very simple question: can they be copyrighted? And this is going to be a question the court is going to have to deal with, and quite frankly, the plaintiffs may have some problems with. So when we talk about copyright, there's a good bit of confusion, which is understandable because it can be a confusing area of law. But there seems to be a belief that you can copyright just about anything as long as it's creative, and that's just not right. So everybody's aware of fair use defenses, which we'll talk about in a second. But there seems to be a belief that if you write it down, for instance, or you perform it, that it's something that's protected. And that's not the case. Let's just look at an example. I'm often asked if somebody can copyright a book title. And the answer is almost always no. And the reason for that is that it's not of sufficient length. And so no matter how creative the 3, 4, or 5 words are that you come up with for your title, we're just not going to allow it to be copyrighted as a matter of public policy, because doing so would be insane. Think about that. We've been publishing books for God knows how many years now, hundreds of years. And at this point, if we allowed book titles to have been copyrighted from the word go, there would be no book titles left. There's just not enough combinations of words. And frankly, the effort and the creativity that you spent on coming up with that book title is probably pretty minimal. And so there's really no reason to save that. Now, versus a book where we're talking about 70,000 words or 80,000 words and what have you, well, in that situation, obviously, we have a sufficient amount of creativity over a sufficient volume of content that we're going to allow for copyright to exist. This also comes up in other areas, food recipes. If you have food recipes online, typically they're not going to be protected by copyright. You can't file a copyright for them because there's not sufficient creativity. Put a tablespoon of butter in the pan. We're not exactly talking poetry here. It's just not an expression that is going to be protected because we're really talking more about facts. There's very minimal creativity, and even if somehow you could dress it up sufficiently to get a copyright for it, to register for it by perhaps adding photos and longer statements about how to perform a voodoo rite over your eggs in the morning to give them more spice. Even then, actually enforcing that copyright in court would probably be pretty difficult. And so that's kind of the aspect that we're looking at with these dances as well. again, I haven't seen these, but I can't imagine the Carlton dance is 5 minutes long. It's probably pretty short. And so are there going to be sufficient number of moves to qualify as a protected work? Well, if we look at the Copyright Act, what we see is that there is a category for choreographed works, but it doesn't really talk about what qualifies and what doesn't. There isn't any limits on it. It's not defining those specific dance steps. So the Copyright Office was apparently hit with this question a number of times. In the mid-1980s, they came out with a compendium in which they talked about the specific steps that were expressed in certain dances and whether they would be protected. And so, for instance, they talked about the hustle, and the set of steps in the hustle that is done, would not be protected because it is not a sufficient volume of creative work to be protected. The fact you do something over and over repeatedly doesn't turn it into a copyrighted work. If I take a title of a book, it's three words long, and I repeat it 20 times down the front of the book, it doesn't suddenly become a copyrighted work. And so I think the plaintiffs in this case are going to have a very difficult time getting over that burden. It's going to be interesting to see if some of these lawsuits are cut off right up front because of that. Now, let's assume that they get past it. Let's assume that the court rules, okay, these are copyrighted works. Well, then is there infringement? And, we can almost bypass the infringement claim because we want to look at the affirmative defense of fair use. And certainly in the Fresh Prince of Bel-Air case, fair use would seem to have a lot of merit as a defense, because let's think about this. I know there are reruns of the show probably on, but how is the show being damaged by this? It has a dance that's being added to perhaps the most popular video game in the world, and most of the people playing that video game have never probably heard of the Fresh Prince, and maybe there'll be a reference to it. How many times have you gone to, you've watched a show and you've heard a song in the show that you thought, wow, that's a great song, I've never heard that before. And you go hunt it down on YouTube and you look in the comments section and there are endless comments saying, oh, I'm here because I watched this TV show that had this song. I'll give you an example. I was watching the show Mr. Robot, and the last episode of the first season, they're having a party and there is a hip-hop song on from, I can't believe I'm going to say this, but the artist Dirty Old Bastard. Now, as a 50-year-old lawyer, you might be shocked to learn that I haven't listened to Dirty Old Bastard in the past. I know, I'm a failure. But I went and pulled up his video on YouTube because I thought it was a great song, and sure enough, it was a great song. I have not particularly become a Dirty Old Bastard fan, but nonetheless, if you looked at the comments section, you would see all these people saying, hey, I heard this song on Mr. Robot. And so it would be very hard for Mr. Bastard to claim that he has been damaged. If anything, he's probably making more money. The sales probably went up, things of that sort. And I think that the fair use arguments in this case certainly are going to have some of those aspects. And so it's going to be very interesting to see how the judge rules. Now, what's going to happen in these cases, just procedurally, so you know, lawsuits have been filed. Going to go through a discovery stage, typically, and there'll be some exchange of information between the parties. And then the defendants are most likely going to file what are called motions for summary judgment. And what they're going to say is based on the evidence presented, the undisputed evidence, there's no legal claim here. And they are going to argue, one, these are not copyrightable works. And two, if they are copyrightable works, there's an absolute fair use defense or something of that sort. The fair use defense issue they'll probably lose on. But are these copyrightable works? That's going to be an issue for the court to wrestle with. And the judge may well decide in favor of the defendants and issue an opinion, or decide in favor of the plaintiffs and issue opinion. And at that point, the parties may appeal those opinions, or they may wait and allow a trial to go and then appeal. But at some point, the loser of this process is going to appeal. It's going to go to the appellate level, and then we'll spend some more time. Briefs will be filed, oral argument will be undertaken, and then at that point, the court at the appellate level will issue a ruling. It'll be a written opinion, and it will either issue a published opinion, which means that it will become precedent for cases in that circuit. So there are multiple circuits in the federal court system. And so every court, every lawsuit that's filed subsequently in that circuit will have to follow that decision. And it will be a persuasive guide, if you will, in the other federal circuits. The court can also issue an unpublished opinion, which would be bad news. because what that would mean is that the opinion would only be binding on these specific cases, not any subsequent cases that are filed. So we're hoping for a published opinion if it gets to that level. Now, if we got really, really, really lucky, the Supreme Court would then take the appellate court's decision up and decide the case itself. And when the Supreme Court decided it, whatever the decision was would become binding law in all the federal courts and all the state courts in the United States. Why do we want that to happen? Not for any legal reason, mostly just for the humor element. So can you imagine oral arguments in front of the Supreme Court with 70 and 80-year-old judges arguing about dance moves in a video game? It would be pretty damn funny. It would probably almost be as funny as the obscenity cases that they took up when the judges were trying to decide what was obscene and what was not when it came to sexual videos. Yeah, that was a tearjerker. It was pretty funny. Some of the statements, I know obscenity when I see it. I was like, really? You do? Well, tell us more, Your Honor. So these are all going to be very interesting decisions. Now, some of these cases include other claims that are also of great interest. There's a trademark claim, for instance, being brought by 2 Millie. He's claiming trademark infringement, and that'll be interesting to see how that plays out. But the one I want to focus on is the right of publicity. Now, celebrities have, anybody really has the right in some states to claim that their right of publicity has been violated. Now, the right of publicity is essentially the right to control the use of your image, your name, your photograph, that kind of a thing, particularly when it's used in a commercial medium without your consent. And so I think we've all probably seen landing pages online where you land on them, and there's this beautiful sales copy that's been created by a copywriter, not copyright, copywriter, two different words. And there's an image of a celebrity and perhaps some odd testimonial below their name. And then you get to the bottom and, they're trying to promote, ground down elephant toenail pills for weight loss or something of that sort, where you're pretty sure the celebrity probably isn't really going to be endorsing that kind of a product. And sure enough, they haven't. Somebody's just taken their image and created a fake testimonial. Well, the celebrity will sue for violation of the right of publicity, as well as many other claims. And under California law in particular is a strong right of publicity statute, and they can recover. And so this claim has been made in a couple of these lawsuits. And really what they're going to have to show is that the dance in the Fortnite video is of such specificity and distinction that when you see it, you immediately think of that individual. So you would think of the actor from The Fresh Prince of Bel-Air, you would think of 2 Millie. And in that situation, then damages should be awarded. Now, the interesting thing about that claim is it doesn't involve copyright infringement. So it's not a question of whether the dance is of sufficient size or creativity to be copyrighted. We just completely bypass that issue. And so that's why these claims were probably included. They're kind of fallback positions. Now, video games are awarded by the courts a very strong free speech protection. And that's traditionally been the ruling in these cases, in any kind of cases with the video game industry. And so it'll be interesting to see if the right of publicity can defeat those free speech defenses. But nonetheless, it is another area where we're kind of looking at case of first impression to some extent, not as much with right of publicity, but it's going to be fascinating to see how it plays out. So ultimately, do Fortnite dance moves qualify as copyright infringement? And the answer is, I think, probably not if I was put on the spot, but you can certainly see an argument the other way, and it's going to kind of be a case of first impression for the court to deal with. Dance moves are just not a highly litigated area of copyright law. I know you're shocked. And so it'll be interesting to see what the court does. If you subscribe to this channel, obviously I'll post future videos on any rulings that come down, rulings of significance in the case. Or even if you don't want to do that, you can just create a Google alert or something for it. And I would definitely keep an eye on it, particularly if you're in the video game industry, because this is a major issue, as to what's allowed and not allowed as far as content goes. But even if you're not, it's going to be interesting because I think there's probably going to be some pretty thorough discussions of copyright law that'll be written in plain English. And if you're interested in copyright or ever worried about it, you'll probably gain quite a bit of knowledge as to how this area of law works. So that's it for today's video. If you have questions or comments, post them below. And thanks for watching. Have yourself a good one.